Well, I'm back again with another story. A new civil case was recently filed against me that is frivolous and based on provable false allegations. The way the court administrator began handling the matter has immediately raised serious procedural and legal concerns. I want to share this experience so that those abusing their positions of power will be held accountable and so that others will receive fair treatment in our courts. The court administrator, remember this name, Irene Semensky, previously told the State Court Administrative Office that I had turned power off to their facility, meaning the plaintiffs who filed the case. This statement was false and entirely based on the unproven allegations in the complaint, not verified facts. Making such an assertive claim unilaterally outside of the legitimate legal determinations was extremely improper and wholly inappropriate. And it raises serious concerns about bias, impartiality, and the fairness of how this case is being handled from the very beginning. And she also added an additional statement regarding the case that was not even contained in the complaint itself. In other words, she made up a story. Yesterday I received a seemingly routine email from the court administrator scheduling a pre-trial conference. At first it appeared to be a standard procedure, setting deadlines for discoveries, motions, and other case management tasks. It began as an attempt to schedule a pre-trial conference by telephone, which already makes it very difficult for me to participate because of my hearing. I voiced my position that due to my hearing disability, I would require accommodations for an in-person meeting. After that, it quickly escalated into the administrator unilaterally deciding that the matter would be resolved immediately through email exchanges, without a proper scheduled conference or adequate notice. She sent a follow-up email this morning shortly after 11 a.m. informing me of the decision to proceed by email only instead of a conference meeting. And then, approximately 2 hours after, she sent another follow-up email stating that if I did not respond by 2, that she would assume the dates proposed by the opposing counsel were acceptable. Shortly after 3 p.m., she sent an email with a scheduling order that was presumably prepared by the court administrator based entirely on the opposing attorney's preferences. Not mine, the opposing person. Attorney, I mean. I was given less than 3 hours from the time the administrator initially email was sent this morning to respond, which is an unreasonably short period that did not allow me any meaningful opportunity to review the rules, formulate a response, or assert my rights. My documented request for an in-person conference due to my hearing disability was completely ignored, further denying me the ability to participate effectively as required under the ADA and Michigan court rules. What the administrator is doing is not only improper, but illegal. Administrative staff have clear legal obligations to stay within their proper role as facilitators, not decision makers, and they must not act in a way that undermines impartial court proceedings or disadvantages one party, particularly a self-represented litigant. Unilaterally preparing orders, making substantive decisions about deadlines, or presenting one party's position as binding violates these obligations will not be tolerated. And I will not tolerate it. So take that to your bank. Well, I hope this does some good, and we'll see you on the next exposure, because they just can't quit doing illegal stuff against me. They're so scared that they're frantic. They lie. They cheat. They're desperate.